Hey everybody, this is Marlene Yvette, and I'm getting ready to go over all the various different steps to how we got to where we are today, where they have a writ of attachment, and at some point we saw an FTA warrant, failure to appear warrant for the 3/30, that's March 30th, show cause hearing as to why I was no longer turning over my baby girl after the condition that she came home with clear poor hygiene, aka physical neglect. And then sadly, after getting confirmed reports that with all the warning signs of toddlers and just the actual findings even from the hospital that were inconsistent and contradicting themselves about the sample they took, why no, I was not turning her back over. I will go over in the next video the CPS penal code and family code that I'm standing on with my duty to protect my child and not only be the one that is causing or allowing any type of abuse or neglect, but also go over the laws that many people are not aware of that puts responsibility on the other parent to prevent their child from being returned or maintained in an environment where they are experiencing neglect and abuse. So I'm going to go through this really quickly because now it's in a position, picture's worth 1,000 words, so just to see there were many steps on the road to get to this point. I'm going to try to go over them very quickly, just simply showing them and then reading what's here. So all of this started here at the top where I was forced to file contempt of our final order that was issued on May 4th, 2015 by Judge Martinez out of the Collin County IVD Office of Attorney General Court. This was regarding medical and also, again, the physical health and well-being of our child, which toddler baby girl, and also reimbursements for medical, so expenses that I was already incurring that he was refusing to reimburse, as well as not providing his contact number. Again, no desire, no history of just calling for no reason, but to be able to keep him in the loop with regards to our daughter. He continued to harass with excessive well-being check emails, all of them that I still responded to. When I say excessive, I'm talking 30, 40, 50 within a short period of time. All asking, saying I'm concerned about the well-being of my daughter after he just found out from medical doctors or from me, say the day before, a couple days before, that she's just fine. Very excessive, quote-unquote, well-being checks. I'm concerned about the well-being of my daughter. And again, I would respond to every single one. But the other reason this was a harassment issue is because he was also emailing an old address. I have our New Life address. That one day he emailed me and asked me to no longer use his work address there at PACCAR or Peterbilt there in Denton. The moment that he noticed me to just use his one Curry Johnson email address, I only use that one as is appropriate under the family court orders. When one party is noticed of the parent's changing email address, he continued to email me as if it was a game to an email address that I would continue to say, please cease and desist, please stop emailing me to that account, and he would continue and continue and continue. His attorney, Kenneth Harder, also did the same thing. So got many emails about that, but ultimately, not a huge deal until now we have returned threats about an aggressive approach tomorrow, alleging that I was refusing visits through Faith and Liberty Place in Dallas, which I wasn't refusing. And so with that, just returned family violence threats, again being the history that he's continued to threaten. This is how people end up shot in the penitentiary and kids come up missing if I were to proceed in fighting for supervised visitation, which I was, as well as child support. With those returned family violence allegations, I was forced to then file a new protective order on 8/20. It says 2014 on this card, but that actually should read 8/20/2015. That's when Plano PD got involved. I made a report with an officer explaining the nature of the threats and the history. He told me it was a terroristic threat. It then got turned over to Detective Frank Dockery of Plano Police Department, and we're going to go over what happened in that situation, or more or less what didn't happen, being any type of real legitimate investigation in that regard. But that was on 8/20/2015 that I filed that, and then I also had to go back days later and file an additional affidavit because after I filed that protective order, I got a notification through our Freedom email address that said people you may know, and it was through Facebook, and it was my daughter's father's mother, so her paternal grandmother, and his niece, so her aunt, His niece is a 20-something-year-old that lives in Louisiana. I met her one time in July of 2014, probably on around the time that we conceived, and I'd never spoken to her since. She didn't have my email address. I didn't have hers, and so for Facebook to prompt that those two people only attached to him and no one else were people I may know to an email address not attached to Facebook, that was a pretty good indicator that what was occurring is what they call a felony impersonation attempt. That is when someone creates a Facebook profile in your name with the intent to harass, stalk, create messages as you. Maybe they're going to create threatening messages and send it to people so then they have a reason to come after you, which at this point he hasn't had any. And so I don't know what his intent was, but it's a felony impersonation attempt to even create the account in my name. Luckily, unfortunately he didn't think that through. It came through to my email address and I did deactivate that account, but I also reported it in that protective order filing. Now I also need to mention that when I filed this new protective order, the Collin County District Clerk's Office decided to secret this filing and they put it under cause number 470-54633-2015, which is a totally separate case from our other family matter case, which was 470-52517-2014. The purpose of the damage of that is prior to a judge hearing a case, also while they're maybe in recess or deliberation or ruling on a matter, they are given the case file to be able to review everything in it. They're at the highest standard of law, so they've got to review all the different factors before they make their decision. Otherwise, they're likely engaging in abuse of discretion or going to be making rulings that are not in accordance with the facts that have been presented, meaning evidence, witness testimony, and not accordance with the law. And so for them to secret it into a separate case, we'll get into just how everybody kind of works together on that. That was not something that should happen. If I were to go to appeal my case, they have to prepare the court record. With it being secreted into a different case, it wouldn't go. Now they'd say, we'll make sure that it goes, but again, it's the same cause. It shouldn't have been separated, shouldn't have had a separate number. But anyways, it did. So then I actually do have my protective order hearing. I requested a default judgment because I was there with a family violence advocate that attends and accompanies to court. And in doing that, we were there on time. Neither Cree Johnson nor his attorney Kenneth Harder were there on time. And so in that being the case, I waited about 30 minutes to ask the bailiff at the time for Judge Chris Oldner in the 416th court where our case was for a default judgment. And what wound up happening